All right, thank you so much for staying with Daybreak. Let's get that conversation on the road, and we'd like to hear your thoughts on this. The hashtag is Daybreak at Trevor Mbij at Citizen TV Kenya. That's how we want to get your answers as to, do you think Parliament should be dissolved? This is the premise. LSK is pushing President Uhuru Kenyatta to dissolve Parliament because it doesn't adhere to the two-thirds gender rule. Simply put, they do not have enough women representation as envisioned in the Constitution. They've tried a record 4 times. Every single time they either come down short of quorum or simple basic support from the members of Parliament themselves. Joining me now is the one person pushing that agenda, LSK President Nelson Harvey, who's with me. Thank you so much for making time this morning. And also Gladys Boss, she's the Uasin Gishu women representative, also with us on this conversation. Let's start with you, Harvey. So you're pushing the president to dissolve Parliament because it doesn't adhere to the two-thirds gender rule. Why now?
Well, Trevor, when the 2010 Constitution was promulgated on the 27th of August 2020, it was the expectation of the people of Kenya that all that was contained in that Constitution will be realized. It is now almost 10 years since the promulgation of the Constitution, yet Parliament has failed to do that which is required of it under the Constitution by enacting the two-thirds gender rule and ensuring that it is implemented. There have been 2 decisions of the High Court which have propelled this action by directing that the National Assembly and the Senate, as well as the Attorney General, take measures necessary to ensure that the two-thirds gender rule is effected. Now, the last of the decisions, insofar as this issue is concerned, was made by the Court of Appeal towards the beginning of last year. One of the petitioners who was before the court approached the Chief Justice with a view to ensuring that the Chief Justice takes action in accordance with Article 261 of the Constitution. But the Chief Justice, for whatever reason, decided to give the 2 houses of Parliament some time, ostensibly because there were some bills pending in the National Assembly and the Senate. It is for this reason, and in light of that background, that it's quite evident that there is nothing more that Parliament and anybody, insofar as that issue is concerned, can do. And the only action that needs to be taken is for the Chief Justice to advise the President in the manner required by the Constitution to dissolve Parliament.
Let's bring in Sholay on this for a bit. And sorry, I missed you there a bit, Harvey. We'll come back to you in just a bit. And you, Madam Boss, you've been serving in Parliament all this time. Is dissolving it the only solution now?
Yes, because I think all methods have been attempted in the past. There's been attempts to pass legislation. Each time it has failed. And we believe that there is lack of political goodwill to implement the two-thirds gender rule, because all it needs is for the majority party. By the way, Jubilee's page number 23, page 30 of its constitution states that it shall and is committed to ensure that the two-thirds gender rule is in fact implemented. So if Jubilee was committed, it would have been a case of whipping its members to vote in favor of that particular bill. But since that has failed, Article 261 of the Constitution says that if Parliament fails to enact any piece of legislation to implement any part of the Constitution, then anyone can go make an application to the High Court, which has already been done. So all measures have been exhausted. And I think, in fact, I think it's coming too late, because the Chief Justice should have already taken judicial notice of the fact that Parliament is unlawful as currently constituted. Because if you, and again, I'll just refer, people must remember this, Article 3 of our Constitution says that every person has an obligation to respect, uphold, and defend this Constitution. It also says any attempt to establish a government otherwise done in compliance with this Constitution is unlawful. So what is happening in the country is unlawful. And this is not about women. It's about the rule of law. The president and members of parliament took an oath of office and swore to defend, uphold, and protect the Constitution. That is all we are asking them to do now.
Okay.
And
let me bring in Harvey again on this. And Harvey, I'll come back to you in just a bit, Madam Sholei. So dissolving parliament now, Harvey, would essentially mean that Kenyans go back to the polls. Is that even plausible at this time of COVID-19?
Trevor, what Kenyans must understand is this. This is not an issue of plausibility. It is an issue of vindication of the rule of law. No wonder, therefore, all the three judges who have had occasion to handle this matter have been affirmative that there was a reason as to why the self-executing mechanism was put in Article 261. The law was designed in such a manner that it is compulsive, it's not permissive. It is not an issue that is at the discretion of Parliament. It's not an issue that is at the discretion of the Chief Justice or the President of the Republic of Kenya. It is intended to ensure that the aspirations, the wills of the people of Kenya are realized. And if I may take you a little bit back, in 2012, when the issue was first brought before the Supreme Court, the question was whether or not we needed to ensure that we have the two-third gender rule implemented before the election schedule for the 4th of March 2013. A majority of the Supreme Court judges were of the view that the implementation time ought to be extended up to the 27th of August 2015. The Chief Justice then was of the view that it had to be implemented before the election schedule for the 4th of March, for the reason that if it was not done that way, there was a possibility that the subsequent parliament will be unlawful. And it came to pass. So we have had two parliaments that are sitting on a shaky pedestal because they're not properly anchored in the law. And if you look at it from that perspective, you realize that this has to be done now. It is not an issue of whether or not we are prepared. It is an issue of ensuring that whoever takes the oath of office performs his or her obligation insofar as the duty to uphold the Constitution is concerned.
All right. Madam Boss, let me take you back to February 27th, 2019, and the motion failed simply because of a quorum hitch. So out of the 75 women lawmakers in the National Assembly at that time, only 20 of them were in the House. And that even raised questions about the commitment of the KEWOPA, which is the Kenya Women Parliamentarians Association. Even though you say this is not a women issue, is there commitment from the people who should be in the forefront pushing this agenda?
I think that the women, and you've had statements from KEWOPA before, have been very committed to and also pushing for this to pass. But remember, even if all the women turned up in Parliament, we still don't have the numbers to pass the bill. And therefore, we are relying on the political parties to push their members and say, this is the position of our political party. We also expect the party leaders to take the front line in ensuring that people do turn up. And not everything that comes to Parliament will always pass. I mean, we've had other bills fail in the past. And therefore, that is why we are falling back on a provision of the Constitution, which is dissolving Parliament. And I mean, and the reason why I've taken this position is I tell myself that, you know, I don't want to go down in history of being part of leaders who did not respect the Constitution. I think it's important that we put that point forward. Yeah, and because as it is at the moment, even the members of Parliament, each and every one of them, male and female, all took an oath of office to protect and uphold the Constitution. And therefore, if they have failed to do that, then let us dissolve Parliament, because that is the option that is available to us. Yes, as a member of Parliament, I wouldn't like to cut my term short, but it is important that this is, because it is something that we owe to history. History will judge us that twice we have failed to implement the Constitution. And if And I always say, when you allow people room to maneuver and not follow the constitution, it could be worse things that can happen in future, because you're setting a precedent where the constitution is not obeyed, and that should not be the case. It is, and this is a straightforward matter. It does not leave any room for the Chief Justice or the President, because it is clear under Article 261. There's been court orders 3 times. The courts have affirmed and reaffirmed that if the law is not enacted, then the Chief Justice should advise the President. It says shall, and it says also that the President shall dissolve Parliament. So there is no room for maneuver whatsoever. And if Parliament doesn't want, if the leadership believe that it's too expensive to go to an election, we shouldn't dissolve Parliament, then they have the choice to pass the law. It is very simple. There are several formulas that have been presented to Parliament in order to on the methodology of implementing that law. I have a bill that is still pending before the House that also attempts to implement the 2/3 gender rule. So if they don't want Parliament dissolved, simple, pass the legislation. It's very easy.
So, boss, walk me through, for argument's sake, let's say, yes, it's being dissolved. What difference does it really make? Because it's the same exact candidates who are still going to go back to the voters to be re-elected. How will that even change the numbers into the 2/3 gender rule?
You know, Trevor, I'm talking about fidelity to the Constitution. The Constitution states that if Parliament fails to enact any law, we can go to the High Court. And after going to the High Court, this is what happens. The Chief Justice advises the President. So all we are asking is we are only following the law. We are not talking about whether who will be re-elected back or not re-elected, but it will send a clear message that we are committed to upholding the Constitution. We are committed to ensuring that we have a lawful government in place. We are committed to ensuring that every letter of the Constitution is adhered to. That is the message that has to be sent. So whether those people are brought back then or not, the next Parliament will know that if they don't enact the law, then it shall be dissolved again, until they get it in their minds that it is important that we adhere to the Constitution.
Okay. Javi, so let's talk about the practical parts of this. How then is the President expected to call for a dissolution of Parliament while Cabinet itself does not even adhere to the 2/3 gender rule? On what moral grounds would he dissolve Parliament?
Well, Trevor, I can see the conundrum in your mind, the conundrum in everybody's mind. But to put it in perspective, it needs to be understood that government, in essence, is a contract between the leader and the people. And the reason as to why this, so to speak, escape module was put in Article 261 was to ensure that throughout the term of the government, it is able to perform its obligation. And the reason as to why the President has no option but to dissolve Parliament is because the Constitution, the contract between the people of Kenya, the legislature and the executive, demands of him that he must ensure that the 2/3 gender rule is complied with. And if it's not complied with, then the contract comes to an end automatically, with the expectation that he whosoever will be back in Parliament, he whosoever will be back in the executive in the new contract, has in mind the need to ensure that the 2/3 gender rule is implemented. What about the Cabinet? It may be a topic for another day, but the High Court has again ruled that the Cabinet of the Republic of Kenya does not conform with the 2/3 gender rule. So the President is really in a predicament, but it is not a predicament that he cannot extricate himself from. All he needs to do is to do that which is required of him under the Constitution, to dissolve Parliament. The question of Cabinet will fix itself as and when the new Parliament is in place.
But Javi, how are you going to navigate the separation of powers issue? Because essentially you're pitting the executive against the legislature now.
Now, the separation of powers question is no longer one for consideration because it was addressed by the Supreme Court in 2012. And the Supreme Court expressed itself quite affirmatively when it said, yes, we have three arms of government. We have the executive, we have the legislature, and we have the judiciary. And the function of the judiciary in this regard is to ensure that the requirement for two-thirds gender rule is met. And if it's not met, the judiciary will make a determination to that effect and have the Chief Justice perform the subsequent role. And after the Chief Justice has performed the subsequent role, then the President of the Republic of Kenya must perform the last role, which is to dissolve Parliament. So that the three arms of government are performing their respective duties. In this regard, the judiciary has performed its duty. The legislature has failed Kenyans for the last 10 years. The executive, which has the power of ensuring that this rule is implemented, has also failed Kenyans. So we are now in the last stages of the termination of this contract. And the head of the judiciary, who is mandated by the Constitution to perform an administrative action of advising the president, has initiated that process.
Okay. Boss, even you've been in Parliament for a long time now. Are we trying to legislate behavior and conscience here? Because there's a pattern under which people vote generally. You're in Parliament, you say you've not been able to get the support of maybe the male or even the female MPs as well. How does this change any dynamics there? It sends a message, but does it change anything?
Yeah, I think what has happened is that we have thought it is okay. We have created a culture where it is okay to ignore the Constitution and the rule of law. And so this step of a by-law society, which I commend, and I also commend the judges who made the decision and the court orders, is to send a clear message. Remember, when you talk about conscience, remember that the reason why we have a constitution and why we have laws in the country is to ensure that certain things are not left to how I feel, my personal feelings, or my conscience. There are certain things that the law dictates that we must do, and we do not have a choice about it. Why is it that we take so seriously that members of the legislature, members of the executive, the ministers, and even the head of state and the deputy head of state are required to publicly take an oath of office? Because it is to let people know that it will not be their personal feelings, but the decision, the dictates of the Constitution. And if we are, why don't we walk around and chopping people's necks? Because the law prohibits that from happening. So we have laws because we are a democracy and we are a country that there has to be order, or else you will be a banana republic. So that message must be sent clearly. And I think this is going to be, for the first time, I think each of the members of Parliament and all the party leaders for the various parties will now realize that this is extremely serious. They cannot take it lightly anymore. And I think it will give them some thinking to do, because I know that what has happened in other countries where the law is very clear, even the head of state takes the initiative to mobilize members of their political party to tell them we are obligated by law to do the following, and therefore we should do it. So it's going to give us a chance to have a conversation as Kenyans and know that we are serious when we talk about Article 3 of where everybody is obligated to follow the Constitution, and that government cannot be formed other than in compliance with the Constitution. I think it's going to be a great time, and history is going to judge us.
Boss, when you say that there's no goodwill to pass this two-thirds gender rule, what does goodwill look like? Because we've seen some politicians and leaders also come out and say that we should implement the 2/3 gender rule. They say that in public, but what are the inner workings of Parliament that we may not understand as outsiders? When you say goodwill, are you talking about inspiring them? And we've seen corruption also being underlying tones. What does goodwill look like?
There are various reasons why I know that there are some members of Parliament who outrightly are ignorant about the topic of equality at all. So they don't even think that it is something that should be a priority. There are other members who know that very well, but it doesn't affect them. They are being selfish and therefore think there is no need to push for equality. But also remember, when Parliament has wanted to pass something, or the government, there has been times when there's been a party position, the leader of majority goes around lobbying members of the party to push for a certain agenda in Parliament. So that's why I'm saying there is lack of political goodwill. Because if the party leader wanted this to happen, he will call people, he will call a party meeting, and he will tell them that I'm going to receive an advice from the Chief Justice to dissolve Parliament. I have no choice. The law does not give me any room to maneuver out of it, and therefore I shall dissolve Parliament. If we want to avoid this, I'm appealing to you to go back. You can even have special sittings and ensure that that law is in fact passed. When they have wanted to pass a law, they have managed to do it. So it is possible. So I think as members of Parliament, we should take full responsibility, but I also think the party leaders should take full responsibility. Okay. But they've always thought, that's what I'm saying, it's about getting away with it. They think they can get away with it. Now that we have been we have gone to the far end of saying we shall dissolve Parliament, then they shall think again.
Okay, so Harvey, is this just simply to twist the legislators or jolt them into action? And also, how far are you with this? Because the Chief Justice is the one who's supposed to write the letter to the President. How far is the process as we speak?
Trevor, and for the benefit of Kenyans, let me just lay the background insofar as the legal position is concerned. And this is the decision that was made by the Court of Appeal on the 5th of April, 2019, when the Speaker of the National Assembly appealed the decision by Justice Mativo insofar as the 60 days that was given to Parliament was concerned. This is what the Court of Appeal said. It is on record that Parliament has undertaken several initiatives, including publishing constitutional amendment bills to implement the gender principle. It is equally a matter of public notoriety, which we are entitled to take judicial notice of, that none of those constitutional amendment bills has ever been debated or considered by Parliament seriously. They have all been lost due to lack of quorum in the National Assembly. That, to us, does not speak of good faith effort to implement the gender principle, and is precisely the kind of conduct that the people of Kenya wanted to avoid by writing into the Constitution, Article 261. Trevor, it is not an exercise of twisting Parliament. It's not an exercise of putting pressure to bear upon the President of the Republic of Kenya. It is what the people of Kenya decided. The day the Constitution was promulgated on the 27th of August 2020, this issue ceased being an issue of debate. And it must be understood that the Constitution is a living document. The Constitution cannot be an edifice of political subterfuge by those who are in power. It must be implemented to the full. And the reason why it must be implemented now is because there is clamor for constitutional change. A question has arisen: is there a need to amend a constitution that has not been implemented fully? For whose benefit is the clamor for constitutional change pursued? Is it for the benefit of the people of Kenya? This is what the people of Kenya said. And for as long as what the people of Kenya wanted has not been implemented, then the government, the legislature, the executive is in office unconstitutionally. And that must be brought to the mind of every Kenyan, because there are those who without the benefit of learning or out of utter ignorance, will say, Harvey is making this push on behalf of a particular political affiliation. No, we are making this push on behalf of the people of Kenya. The people of Kenya are our clients so far as this matter is concerned. And the people rank paramount insofar as this constitution requires that the two-thirds gender rule must be implemented.
And you are completely divorcing this from the BBI, because the BBI is also suggesting, there was a suggestion that it might end up bridging the two-thirds gender rule gap.
Trevor, BBI is an acronym that does not make sense in constitutional law. We've spoken about this time without number, and we've said, for you to amend the Constitution, first you must undertake an elaborate constitutional review process to establish what is the problem with the Constitution. Has that been done to give foundation to the BBI clamor? I don't think so. Constitutional amendment must also be preceded by views of the people. Has that been the case? No. So to that extent, we cannot say that we are ripe for constitutional amendment when we have not implemented fundamental facets of the Constitution.
Okay. Shole, and the question for you here is, you have a bill already in Parliament as well. If we go the appointment way, what is the best way of getting to this, the nuts and cracks of this? Because I foresee a situation where there's going to be a bit of a quagmire when it comes to dissolving Parliament. There'll be a lot of legal battles here and there. What is the best way of resolving this issue, and what did you suggest in your bill?
My bill had a formula that would ensure that we would be able to implement and meet the two-thirds gender principle. And I know at the stage that where my bill got stuck, it went to the budget committee. The budget committee went through it. They got a report from the National Treasury, and the National Treasury's report was that it was going to be too expensive. I remember I went twice to the National Treasury myself and spoke to the various officers who were involved. And I explained to them that this is not about how much it will cost. It's about implementing the Constitution. When the Constitution says we'll have 22 ministers, you cannot, you'll have ministers. You cannot say, oh, we can't have ministers because it's too expensive. Or we can't have 47 governors because it's too expensive. So Treasury also needs to know they do not have a choice in this whatsoever. It is not for them to decide, because the Kenyan people already, when they passed and approved this constitution, that decision was already made. It is not for Treasury to pick and choose which parts of the constitution they feel they can afford or cannot afford. And even then, when we had discussions with the National Treasury, I told the National Treasury it will only take by 0.2%. That is to be the increment that would be by implementing the two-thirds gender rule. So, and that is why there is a thought that people can bend the rule of law when they want to. And that's why you have people like the National Treasury making such preposterous suggestions. And the message should go clearly to them. It is not for you to decide. If you think something is too expensive, then start a constitutional amendment process. But don't make the decision at your desk at the National Treasury.
All right, let's wind up this conversation, and I'll start with you, Harvey, give you a chance for closing remarks. Is there a plan B should this fail, like all the other initiatives that have failed before?
This is a one-way ticket, Trevor. There's no plan B. It's for the Chief Justice to do that which is required of him under the Constitution. If he doesn't do what is required of him under the Constitution, then it will be evident that he will have misconducted himself. And under the Constitution, misconduct on the part of the judge, the consequences are set out there. What about the president? If he's advised to dissolve Parliament by the Chief Justice, again, there is no plan B. He just has to dissolve Parliament. If he doesn't dissolve Parliament, then there'll be gross misconduct on his part. And the Constitution is also quite clear on the consequences of gross misconduct on the part of the President of the Republic of Kenya. The question will be, who will be the one to take charge of the gross misconduct on the part of the Chief Justice or on the part of the President of the Republic of Kenya? If we interrogate that question further, the people of Kenya know best how to handle this issue. I don't think they suffer want of expertise on how to wriggle out of the problem.
Okay. Boss, do you guys have a plan in Parliament? Kewopa maybe? What are you mulling as options?
I haven't had a Kewopa meeting over this, so I can't say what the Kewopa official position is. But this is my position as a member of Parliament. My position, and as a lawyer, I know the law is clear on it. And therefore, I support the adherence to the Constitution. And Trevor, I think it's good to close by reading this out clearly to Kenyans because they seem to forget. Article 261, subclause 7, it says, if Parliament fails to enact legislation in accordance with an order under clause 6b, the Chief Justice shall advise the President to dissolve Parliament. It says shall advise the President. It doesn't say may, it says shall. It's compulsory. And then it goes on to say, and the President shall dissolve Parliament. So the Chief Justice and the President have no choice. The law demands and the Constitution demands of them. The Constitution that they swore to uphold, protect, and defend has told them this is what they must do. So there is no room for maneuver whatsoever on both the Chief Justice and the President.
All right. Honorable Gladys Boss, thank you so much for speaking to us as the Uasin Gishu Women Representative. And also LSK President Nelson Harvey says this is a one-way ticket and the President must now dissolve Parliament at this point. We'll follow up on this discussion and let you know what happens. We're taking a quick break here on Daybreak. When we come back, we're talking about something different. It's just about 2 days since the international flights resumed, about 2 weeks after the domestic ones resumed. We'll find out from the people in the tourism sector how this has affected them and how travel will look like in the COVID-19 era. But for now, we're taking a quick break on Daybreak Home Edition. See you in just a bit.